Broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone. Thanks for coming out. My name is Marvin Schwartz. I'm the COO at hrsimple.com, and we're glad that you're with us today. Would like to also say hello to Olivia Hochschwender from the law firm of Kastner, Westman, and Wilkins. She will be going over effective documentation and employment audits with you in just a minute. She is from the law firm of Kastner, Westman, and Wilkins. Like I said, they author our Ohio Human Resources Manual, which is also available for purchase on hrsimple.com. If you happen to live in the beautiful state of Ohio, make sure you check that out. hrsimple.com is an HRCI approved provider and a SHRM recertification provider as well. And we will show you all these codes at the end of the presentation. We also post all our webinars to youtube.com/hrsimple. So if you don't have a pen and paper at the ready, please check out our YouTube account early next week for the full presentation. Today's presentation lasts about 60 minutes. We'll have some extra time for questions and answers at the end. Enter your questions in the question or comment boxes at any time during the webinar, and we'll try to get to all of them. And now for a little background information here for Olivia. Like I said, she's with the law firm of Kastner, Westman, and Wilkins. Her practice includes all aspects of labor and employment law, including litigation, workplace investigations, representation of employers before a vast area of federal and state administrative agencies, and of course, advising employers on day-to-day employment decisions. So without any further ado, Olivia, I am going to pass this over to you and let you get started.
All right. Thank you, Marvin. And thanks everyone for being here for effective documentation and employment audits, including auditing of the supervisor, a very, very interesting topic. Just a few housekeeping items before I dive into all this material. If you have any questions, as Marvin said throughout the presentation, feel free to ask them as we go along. And before we dive in, I just wanted to say, just give everyone a little bit of a warning that there is a ton of information here. We likely will not get through all of it in a ton of detail, and there may be a couple slides that I skip just in the interest of time. However, I believe Marvin mentioned that the presentation will be available at a later date on YouTube. And one last thing, just a little background on this presentation. You'll see that each slide mainly consists of a series of questions, and these questions are designed to get you thinking about ways in which you can improve your HR practices, procedures, and processes. So you can use these presentation slides as kind of a roadmap if you ever do choose to perform an HR audit in the future. All right, so let's get started here. All right, so what is an HR audit? Well, simply put, it's a comprehensive review of a company's policies, procedures, documentation, systems, functions, and practices from an HR perspective. An audit can be as simple as reviewing your employment files just to make sure they're in order and you have certain records, everything like that. Or it can be as broad and complex as reviewing your entire HR department. Why do you want to audit? HR audits help determine whether specific practice areas and our processes are adequate and effective. And they can also minimize lawsuits by ensuring that employers' policies and procedures are legally compliant. So we will talk about going over your handbook and your policies and procedures to make sure they are in compliance. This could help avoid lawsuits in the future. So it's another reason you might want to perform an HR audit. All right, so one first target area of an HR audit is an HR systems function audit. And the first area we like to focus on is looking over your hiring practices. So with respect to hiring practices, one key area you want to look at first would be your advertising. When you post jobs online, probably not in the newspaper anymore, but mainly online, right? So with respect to your job postings, you want to look at them and you want to see, do they indicate a preference for a certain type of applicant? So for example, if you have a job posting that says seeking recent college graduates, well, that could be construed as discriminating against older applicants. So that's something you want to check. You also want to look at your job descriptions. You want to make sure they're current and accurate, and you want to make sure they include all essential functions of the job, which we'll get into later in this presentation, but it's really important for specifically ADA purposes. You also, if you use third-party companies that do your advertising for you, you probably want to make sure that their ads are also legally compliant. For example, we had a client who used a third party to post their jobs online. They will not be named, but in the ad, it notified applicants that if they were employed under federal law, they would have to notify the employer every 5 years about any disabilities they had. First of all, there's no law that exists that says that, and in fact, that could violate a couple other laws I know out there. So you want to make sure if you are using third parties that their ads are legally compliant as well. All right, another area in hiring practices to audit, you want to take a look at your job applications. With respect to your job applications, first area, you want to look at whether your application contains a statute of limitations waiver. I'm sure some of you have heard of this, but I know my associates and I, we really advocate for these in applications as well as in at the end of a handbook. So you could put in your application to limit the statute of limitations waiver. And we practice specifically, not always just in Ohio, but I know several Ohio courts have upheld the use of a statute of limitations waiver. And we usually advise that we significantly reduce the waiver, the statute of limitations down to 6 months. In Ohio, I know a lot of times an employment law claim is 6 years. So that's a big reduction there, something good to have in an application. And additionally, you also want to make sure the application is on its face legally compliant. So legally compliant, what are we looking for? You want to make sure there's an EEO statement on the application. And you also want to make sure the application does not elicit protected class information, whether it's indirectly or directly. So for instance, you have an application that asks an applicant to list the years they graduated from high school and college. That could elicit protected class information because you could get their age. So rather than having asking for the years they graduated on high school or college, you can ask what levels they've completed, what high school or college they went to, but you should avoid asking for years of graduation. Other legal compliance issues with an application, you want to again make sure the application does not directly or indirectly inquire about an applicant's disability. And additionally, you want to be prepared to offer reasonable accommodations to applicants on your application as well. All right, and you also want an at-will disclaimer in your application. Always a really good practice. All right, moving to ban the box. I'm sure most of you are aware of ban the box, and I know there's been a movement across the country to ban the box. But simply put, several states and cities have moved to prohibit employers from having the box on an application that asks if they've ever been convicted of a crime. I know in Ohio, this usually only pertains to public employers, but there are states across the country that have banned the box for private employers as well. This is not a comprehensive list, but I know Connecticut, Illinois, Minnesota, and New Jersey have all banned the box. So you definitely want to make sure your application, if you are in one of those states, that you do not have a box asking that question. All right. Next in the hiring process, I'm sure many of you perform background checks. So with respect to background checks, you have two main areas we'll go over, the Fair Credit Reporting Act, and then how you can use social media to perform background checks, why you should, maybe why you shouldn't. So with respect to the Fair Credit Reporting Act, mainly, you mainly just want to make sure if you are using third parties that they are complying with the Fair Credit Reporting Act. And I know recently a new form has been issued, a summary of rights form has been issued that employers, if they do take an adverse action based on a background check, would have to give an applicant. So you want to make sure that your forms are up to date, everything like that. All right, let's talk about social media. So I'm sure many of you are at least on social media. Whether you use social media to perform background checks on applicants is another question. But it can be a great resource. Facebook, Instagram, LinkedIn, they're all free, and they can provide information that is otherwise inaccessible through formal background checks. We all know what you can find on Facebook that might not be in a background check, right? Although this information is great, it can often be unreliable, and it can expose an employer to protected class information. So if you're going to use social media to perform background checks, we suggest a couple of best practices to implement. You want to assign the actual investigating on social media to a non-decision maker in the hiring process. And that way, if that non-decision maker will most likely be seeing protected class information, but he or she does not need to relay that to you or a decision maker. He or she just needs to relay job-related information to you. So that could avoid protected class information being transferred to a decision maker, and it could avoid a failure to hire claim down the road. Again, you do not want to document protected class factors, only consider job-related criteria, and be consistent. If you're going to do social media background checks on one employee, you should most likely do them for all, or at least all all applicants applying for a certain position. All right, moving on to the interviewing process. So with respect to interviewing, you first want to start with the interviewers when you're auditing your interviewing process. So first determine who's involved in the hiring process and have those involved received proper training. Do your supervisors or managers, those making hiring decisions and conducting interviews, do they know what they can and cannot ask? For example, you don't want to ask open-ended questions that could elicit protected class information, such as, tell me about yourself. Do you have any kids? It may seem obvious, but the number of times we have clients who had someone in there who was not trained, and I know one time we had someone who, like 1 week on the job, the supervisor asked So to the applicant, have you recently taken any FMLA? Just a no-no. So you just need to make sure that they're properly trained. You also want to make sure that individuals know why they should or should not hire an applicant. And again, that they're trained in the use of social media as well. You want to make sure interviewers have clearly defined criteria for judging the applicant's qualifications, and that should be done before the interview starts. And I know we are in the day and age of online video and interview instructions. Just like I am today, I'm just talking to a computer. There are interviews where you just talk to a computer and you answer questions. And there's really no back and forth. You want to make sure these questions are legally compliant as well. All right, with respect to interview questions, again, when you are auditing your hiring practices, if you have standard interview questions or script, it's easy just to pull that out of a file and check to make sure they're EEO-ADA compliant. However, if you do not have standard interview questions or scripts, you would want to make sure you meet with those involved in the hiring process and train them again on what they can and cannot ask. And you also want to make sure those involved are asking only relevant job-related questions. With respect to interview notes, again, if you use a standard form, you can pull that out and see and review them. If not, you may have to collect them from individuals who have taken notes during interviews. You want to make sure these notes express objective, factual reasons that support a decision to hire or a refusal to hire a candidate. And again, you want to make sure these notes do not document protected class or inappropriate information, all to avoid any failure to hire claims. Another area in the hiring process you want to be aware of is, again, offering reasonable accommodations for an interview. I know we talked about that for an application, but the company employer needs to be prepared to provide applicants with reasonable accommodations, and your supervisors need to be trained that they need to know that they most likely will have to provide a reasonable accommodation depending on the request. A good example of this is Target has been in the news several times for failing to do this. Specifically, one case, the EEOC sued Target for disability discrimination. In that case, we had an applicant who was deaf, and Target had called him to leave a message to schedule an interview. And when they called him, they got this voice recording system, which somehow took the voice message, is able to take a voice message and translate it into sign language so that he can understand the message. So Target was tipped off to the fact that this applicant was deaf because of the voice recording system, and they did not leave a message. They called again, and same thing, they did not leave a message. And this deviated greatly from Target's normal practices. By that time, usually, once Target had made a call to schedule an interview, they were interested enough to leave a message. And later, I know the applicant did go into the store, talk to the HR manager. He was assured that Target would be calling him to schedule an interview, and he never got an interview. And it later came out that Target hired 7 non-disabled applicants. So the EEOC alleged that Target discriminated against this applicant because of his disability. There was another very similar case like this, and Target settled for $88,000 just for, they didn't even get to a hiring process, just in the interview process. So something to be aware of and to train supervisors on. All right, moving on to employment testing, mainly in the area of pre-employment, since we're talking about hiring practices. So if any of you perform medical examinations, you want to audit your practices and determine at what point you are performing these tests, whether it's pre-offer, post-offer, or once an employee is hired. Obviously, pre-offer, that is completely prohibited under the ADA. If it is if you perform a medical exam post-offer, that is okay so long as it's done for all entering employees in the same job category. And then moving on to once an employee is hired, medical exam can be performed only if it's job related and consistent with business necessity. I'm sure most of you perform drug testing. So with respect to drug testing, you want to audit your drug testing practices. You want to determine whether all state or local requirements are met. You want to look at whether the employer has a written drug testing policy, whether all applicants for the same job are tested similarly. You want to look at, make sure proper notice has been given to applicants. And again, you want to determine at what stage the drug testing is being performed. All right, and now there are a ton of other types of employment tests and selection procedures that can be performed. I'm sure many of you perform some other tests, such as any cognitive tests, medical tests, physical ability tests, personality tests, English proficiency tests. The list continues. So when we're talking about any type of pre-employment test, any type of screening, you want to make sure that the main concern is whether these tests have an adverse impact on members of a protected class. So for example, if you're performing a strength test and that strength test disproportionately screens out women, that could have an adverse impact on women who's a protected class. However, an employer can perform this test if they can prove that it is job related and consistent with business necessity. And how do you go about determining that? Well, the EEOC has come up with their uniform guidelines on employee selection procedures. And you can validate your test by using these guidelines. They were developed by the EEOC, and I know there are 3 ways in which an employer can show their employment test is job related and consistent with business necessity. Sorry, I skipped ahead a bunch of slides here. My apologies. Just a little preview. Okay. And one of the last areas with respect to hiring practices would be offer letters. Now, you want to look at your offer letters, and very important, you want to make sure they cannot be construed as creating any type of an employment agreement. A lot of times an applicant will, if they have to sign off on the offer letter, they feel like there is an employment agreement because an offer has been made and they accepted it by signing. However, that's not the case, typically not the case. And with respect to that, having an at-will disclaimer in an offer letter can help you avoid the appearance of the offer letter creating any type of employment contract. Now, the only time, well, there are a couple times you cannot have an at-will disclaimer in an offer letter would be if you are in a unionized environment where this offer letter would be sent to a collective bargaining employee, or if you know that this employee you're going to hire is going to be under a certain type of contract. Also, with respect to offer letters, you want to examine your practices and determine whether you are sending the same or similar offer letters out, or whether different supervisors or managers are sending offer letters out. If so, they could vary. You want to make sure they're consistent. All right, so that is it for hiring practices, auditing your hiring practices, some key areas and questions you want to focus on. Moving on to auditing your compensation and payroll systems. Now, with respect to this, we are going to mainly talk about employee classifications and wages. So moving on to employee classifications. Here we're talking about whether your employees are classified properly as exempt or non-exempt employees. So with respect to exempt or non-exempt, if exempt, do your employees' actual job duties support their classification? Remember, just because an employee is paid a salary or has a certain job title that makes it seem like they should be exempt from minimum wage and overtime does not mean anything. It's their specific job duties that determine whether they are exempt. So reviewing those job duties to make sure they are properly classified is a wonderful idea. Additionally, you want to determine whether employees are properly classified as full-time or part-time for ACA purposes. And with respect to, lastly, on employee classifications, with respect to independent contractors, if you use independent contractors, again, just because you call him or her an independent contractor does not mean that employee really is an independent contractor. So you want to make sure that an employee, well, individual really is properly classified as an independent contractor. And the Department of Labor uses a 6-factor test called the economic realities test. You can Google that. Pretty straightforward test that weighs certain factors to determine whether an individual is an employee or an independent contractor. And you also want to make sure, if you use independent contractors, that you have good independent contractor agreement in place with that individual as well. All right, moving on to wages. Pretty obvious, but you want to make sure all employees are being paid at least minimum wage. And you can also do an audit to determine whether your wages are competitive with others in the industry as well. With respect to FLSA classification and wages, this is overtime mainly. Are your non-exempt employees being paid for all time worked? Are you properly calculating the overtime rate? Is all required compensation included in this calculation? Additionally, are supervisors aware that non-exempt employees must be paid for all hours work regardless of whether such work was approved? And that goes to a situation where if an employee works overtime, he was not authorized to perform that work, but he still did it, you still have to pay him. You can discipline him for not getting authorization to perform overtime work, and you'd want to have a policy to that effect, but you still have to pay that employee. All right, exempt employees. You want to make sure they are being paid on a salary basis. And what's most important here is you want to make sure improper deductions are not being made from their pay. I have on here a note, a question: do you have a safe harbor policy? I will talk about that more in about 5-10 minutes. So how can we avoid any misclassification, or excuse me, any misclassifications with overtime and failing to pay employees overtime? Well, you want to make sure that the employer has a great timekeeping policy, and that supervisors are taking steps to make sure that time cards for hourly employees accurately reflect all time spent working. You also want to look to see whether your payroll and HRIS systems collect and maintain all required information as well. Wage increases. When auditing your wage increases, you want to look at what criteria is used to determine wage increases. And you also mainly want to look at whether you have any increases that could violate the Equal Pay Act. So you want to monitor those wage increases. And so, for example, if you notice when you're auditing the wage increases that a disproportionate amount of males are receiving wage increases as compared to females, that doesn't mean it's a per se violation of the Equal Pay Act, but it should give you a red flag and say, look, you probably need to check into this and determine what is the underlying reason why there is this difference. All right. Okay, with respect to benefit plans. Now, this is definitely not my area of expertise. I know in our law firm, we have a specific person who is the benefits guru, but I have put together some questions that you should ask yourself with respect to benefit plans. You want to first make sure that employers met the various notice requirements of the ACA, COBRA, and HIPAA. Additionally, you want to make sure benefit plans and the administration of such plans are legally compliant. For example, you want to make sure your healthcare coverage provides the same benefits for all active employees, regardless of age, sex, race, etc. And lastly, I know this is brief on benefit plans, but with respect to wellness programs, you want to make sure specifically that if you have one, it complies with the ADA and ACA and any other laws and regulations that may come into play there. All right, so that is it for HR systems functions audit. We're going to move on to an area we titled it Other Legal Compliance Audits. So in this area, we are focusing on employer records and agreements, handbooks, policies and procedures, leave management, OSHA issues, and performance management. So first, on the subset of employer records and agreements, we have our first handout here talking about personnel files. I'll get to that. It's not wanting to launch. But you can click on the handout to look at the personnel files here. And I've composed a list of what you want to include and what you don't want to include in your personnel files. So just briefly, I know most of you probably are aware of all this, but with respect to personnel files, what do you want to include? Hiring, termination documents, application, resume, reference checks, offer letter, all the things we've gone over, etc. You want to include employment agreements, anything related to performance management. You want to include that employee has acknowledged that he or she has read and complied with all of your organizational policies. And with respect to compensation and benefits, W-4s, W-2s, any direct deposit, commission, bonus calculations, or any benefit enrollment or beneficiary designation forms, that all should be included in the personnel file. What not to include: medical records, supervisor files, investigative files, and just any unnecessary documents that would just take up room and clutter the personnel file. So with respect to medical records, what do you want to include in there? Well, you want to include medical questionnaires, benefit claims, doctor's notes, accommodation requests, medical leave records, and workers' compensation claim records. So the big thing on that is what not to include probably in personnel files. Medical files should be separate. All right, confidential files. I don't know if any of you keep a separate confidential file, but I've been told that this is becoming a popular practice in the HR area. I don't know of many of our clients that do, but I do know of some that don't necessarily have a separate confidential file, but have a tab in a personnel file with confidential documents under that tab, which is not a bad idea. So confidential files, what are we talking about here? These are documents that should not be accessible to managers and supervisors due to the sensitive nature of the information. What type of documents are we looking at here? Anything that would contain a social security number, criminal history, immigration status information, marital status information, or protected class information. So what to include in a confidential file? These are just some areas to include. And in the interest of time, I'm not going to go over every single one. I want to make sure we get through everything. All right. When you're auditing your employer records and agreements, you want to look at what type of employment agreements have you entered into with employees. For example, we had a client, and excuse me, when you're looking at these agreements, you want to make sure they jive with your other policies and procedures. For example, we had a client who had an employee sign a separate confidentiality agreement, and then the employee had already entered into another confidentiality agreement by way of signing the employee handbook. And the client went to enforce this confidentiality agreement in court, and it came out that these two separate confidentiality agreements were completely in conflict. I'm not totally sure of the specifics, but they were completely in conflict and they were not enforceable. So you want to make sure that if you do have employment agreements, they do align with anything else you have in your handbook and policies and procedures. You also want to look at...
Excuse me, Olivia, there's one question I'm seeing here that's asking if it's okay to put workers' comp medical files in with the regular medical files.
Yes, that should be fine. Yeah, so long as you're not, putting them in the personnel file. I know a lot of our clients have a separate workers' comp file, but I think that mainly is probably for organizational purposes rather than any legal purposes. Any other questions? Sorry if I haven't been answering any. Okay. All right. Moving on to, where were we here? When we're looking at agreements, employment agreements, you also want to look to see, are they really appropriate for every employee? Are they really appropriate, a confidentiality agreement or a non-compete agreement? Is it really appropriate for certain rank and file employees or a clerical worker, unless for some reason that specific worker had gained access to confidential files through her, his or her time at the company. It may not really be appropriate for every employee. And then you also want to make sure, are these agreements being enforced? All right. Okay. And lastly, with respect to records, employer records, obvious, easy, but make sure all state and federal required postings are posted. Minimum wage overtime, EEO, OSHA, etc. Just make sure they're posted. It's very simple to do. And you want to avoid penalties for failing to do it. All right, moving on to key policies and procedures. What must you have? What should you have, really, in your handbooks? And I've identified various ones here, so let's go through them. One big one is an anti-discrimination, anti-harassment, and an anti-retaliation policies. You got to have them. And with respect to them, in these policies, you want to make sure all protected classes are included. Now, if you are a multi-state employer, this is important for you because protected class can be defined differently depending on what state and even city you operate. So for example, I know in Ohio, the state of Ohio does not include in the definition of protected class, they do not include sexual orientation or gender identity, but the cities of Cleveland and Akron do. So you really have to make sure, depending on where you operate, that you have a good definition of what is a protected class in your anti-discrimination, harassment, or anti-retaliation policy. You also want to make sure there is an adequate complaint procedure and a good description of the complaint procedure. You also, in that description, you want to assure employees that there will be no retaliation and that the employer absolutely does not tolerate any retaliation for an employee making a complaint or participating in an investigation of a complaint. Additionally, you want to assure that the employer will protect the confidentiality of complaints to the extent possible. Okay, what other good policies, key policies should you have? You want an EEO policy. An employment at will disclaimer in your handbook is also a really good thing to have. And with respect to the Fair Labor Standards Act related policies. So I mentioned probably 10 minutes ago about a safe harbor provision in your handbook. When I talk about a safe harbor provision, this is what I'm talking about. Generally speaking, if an employer makes improper deductions from an exempt employee's salary, the employer could lose the overtime exemption for that entire class of workers to which that employee belongs. But this can be avoided if an employer has a provision in their handbook that assures an employee that they will not make improper deductions from a salaried employee's paycheck. And if they do happen to make an improper deduction, that they will rectify it. And also that employees need to come forward about these improper deductions so the employer knows about them and they can remedy them. Now, this does not, I've had people ask whether they actually have to title this provision as a safe harbor provision. You don't. You could have it, anywhere in the handbook with any title, but it's good to have. All right. You also want a policy that prohibits unauthorized overtime. I spoke to this earlier ago, but you still have to pay an employee for any unauthorized overtime, but you can have a policy stating that if an employee does not seek permission to work overtime, they will be disciplined. And you also, again, like we talked about before, want to ensure you have a timekeeping policy. All right, a couple other policies, key policies you should have. If you have 50 or more employees, you should have an FMLA policy. Obviously, that goes over what FMLA is, but you should also in that policy have information on whether an employee has to use accrued leave concurrently with FMLA leave, and how how you calculate the 12-month period. You also want to make sure you have, if you don't have an FMLA policy, probably you want to have a leave of absence policy, a non-solicitation and non-distribution policy, a good electronic communications and social media policy, especially considering everything is online and via email now. A workplace violence policy is a great one to have. And of course, you want a good policy that talks about, these are a list of the standards of conduct. These are specific rules. So if an employee does violate them, you can point to, Rule 15 to discipline or eventually terminate an employee if need be. And lastly, you want an acknowledgement form that your employees acknowledge, they sign in the acknowledgement form that they have received the handbook, they have reviewed it, and agree to follow it. All right, moving on to unwritten policies. It's a good thing to audit. You want to talk about whether you have any unwritten policies. So who created these policies? Are all employees aware of these policies? Probably not. So that's a good thing to ask yourself. You also want to determine whether they conflict with any written policies. This is a big one. And if so, you need to determine which one's more important. And what else? You want to talk about, you want to review to see how these policies can be accessed. And when you review these unwritten policies, if you find any, determine whether they're necessary, and if so, you need to memorialize them. So I have a good example of a client who had a very specific dress code policy. This client required employees to wear a black suit at all times on the job. And an employee on the first day showed up to work. She was notified of this dress code policy. She showed up to work without a black suit on. Employer warned her. The second day, employee again showed up to work without the black suit on. She was warned again that she had to wear a black suit because of their very strict dress code policy. That day, she notified her supervisor that she had a medical issue and might need to take leave. The following day, she showed up without a black suit on and she was fired, pursuant to the dress code policy. And we asked the client where we could find the policy. It wasn't written down. And it looked pretty bad that they fired this employee who had just most likely requested leave because of a policy that was not written. So it's really important. If they are important policies, they need to be in a handbook and memorialized in writing. Lastly, with your policies and procedures, you just need to make sure they are up to date, they're legally compliant, and they're consistently applied. You should review and revise your employee handbook and policies each year to ensure each policy is accurate, necessary, and compliant with federal, state, and local laws. I know it may seem like a lot to review it each year, but if you do it each year, it doesn't require as much time as you may think. Just because, there are not that many changes in the law each year, unless for some reason there's a big overhaul in the state law. You really should not have to make any changes, that many changes. All right. Another area of legal compliance audits is leave management, specifically the FMLA, which I know everybody loves the FMLA, right? So when you're reviewing your FMLA practices, you want to make sure, as I've already said, that the company, if you have 50 or more employees, has a written FMLA policy that states all of the requirements for FMLA to apply. You also want to have a procedure for what happens when an employee requests FMLA leave. As we have already talked about medical files, you want to make sure that steps are taken to protect employee medical information. And again, with respect to third parties, if you have a third party performing FMLA leave for you, you need to make sure that this party is properly handling FMLA requests. All right, another area to review is your return to work testing. So when you're reviewing this, you want to determine whether the company, obviously, whether they first perform any return to work testing, and under what circumstances are you performing testing? Do you perform testing when an employee returns from FMLA leave, or when an employee returns from leave due to a workers' comp injury? And what type of testing is performed? Are you just performing agility tests, or are you performing, more in-depth medical examinations? If so, could your testing be construed as an unlawful medical examination under the ADA? So for example, physical agility tests, they're typically not considered a medical examination. But If a physical agility test goes a little farther and said, rather than testing an employee who is out with a shoulder injury to see if he can lift 50 pounds, you test that, but you also take his blood pressure, and then you ask him about his medications, and you start reviewing a medication list, and then you have a doctor interpret that. That could be considered a medical examination. And if so, it has to be every part of that examination has to be job related and consistent with business necessity. And it has to be limited in scope to what is needed to determine whether an employee can safely return to work. So you want to make sure you examine the types of tests you're performing. Yes, that's a slide I just talked about. And all right, return to work accommodations, short and sweet. We've already kind of talked about, we did talk about reasonable accommodations during the hiring process. But with respect to return to work accommodations, you all, I'm sure, are familiar with, the ADA, workers' comp light duty, and the interplay between FMLA and other various laws. So you just want to make sure you review your practices with respect to worker or return to work accommodations, and make sure your supervisors, again, are trained in what could be a reasonable accommodation, and trained in, the ADA interactive process to provide a reasonable accommodation. All right, moving on to some OSHA issues here. When you're reviewing your records, you want to make sure that all OSHA records are being maintained. You want to make sure that the employer has assured its employees that it will not retaliate against those who report safety violations. And another big one with respect to OSHA is when you review your safety policies in your handbook. You want to determine whether an employer has a policy that discourages employees from reporting an injury. Whether there's a policy that disciplines an employee who fails to immediately realize that his or her injury should be reported. The problem with the second one is that OSHA is of the opinion that if you are immediately disciplining an employee who fails to immediately realize that his or her injury should be reported, that could discourage employees from reporting an injury. And if an employee gets hurt and, at first blush, I don't think I really need medical treatment. And then they don't report it for maybe another day or two when a cut or bruise or their arm really starts hurting, they could be disciplined for that. And if they know that, they might not report it at all. So that's the problem. OSHA does not want employer policies to discourage employees from reporting an injury. So you want to check your handbook, your safety policies with respect to that. You also want to make sure the employer knows how to properly report a workplace accident and injury. You want to ensure that you're conducting safety training for employees. And also, do you know what to do if OSHA knocks on your door without any notice? These are all good things to review.
Olivia, I have one more question for you if you want. It says,
all right.
Says, can the acknowledgement of policies be electric, or does it have to be a wet signature? It says, example, confidentiality agreement, arbitration agreement, an employee handbook, etc.
No, it can. You're talking about electric, like via email or electronic signature, right? I'm assuming.
I believe so, yes.
Yeah, that's fine as well. It doesn't have to be, pencil, pen to paper. So long as you have, something documented on file that shows this employee acknowledged that they understand these policies and procedures and they're going to follow them, then that's significant. That should be fine. Any other questions? All right. Okay, performance management. So when you're auditing your performance management practices, a good place to start is if you have performance evaluations. Do you have a system for evaluating employee performance? Hopefully you do. If not, you should have one in place. And most importantly, you want to determine whether this system is consistently followed. So for example, our supervisors, are they truly following the system and truthfully and accurately evaluating employees? Or are they being too nice? Are they, giving 5 out of 5, but when in reality that employee really should have gotten maybe a 3 out of 5? Are they ranking employees without giving a good description of why they ranked an employee a 3 out of 5? Very good to train supervisors on. And additionally, you want to make sure employees are provided with written job expectations. You want to make sure employees know what's expected of them. And if they do know and they're failing to meet those expectations, then you can turn, if you would ever receive a charge for discrimination or like that, or something like that, you can show that this employee received a written job expectation and they failed to meet that expectation. They had notice. All right, terminations. This is our second handout. We could spend hours and hours and probably days on terminations. So I put together a checklist, a good evaluation checklist that you should review before you make the decision to terminate someone. So these are just questions and concerns you should consider before terminating an employee. In the interest of time, I know we only have a couple more minutes and I want to make sure we get to supervisor audits. So looking at this handout, you'll see we have questions based on whether you're considering an involuntary termination or whether it's a RIF or layoff. It also asks questions about contract concerns. It asks you to examine whether there's any type of employment agreement, a collective bargaining agreement that might govern a termination, and any handbook provisions as well. There's a whole section on if you have potential discrimination concerns with the termination. And that goes both with Title VII concerns for discrimination, and then also with respect to ADA or workers' comp and FMLA. It asks you questions, has this employee had any recent medical or personal leaves of absences that you would probably want to take into consideration before taking any action on them. It also discusses retaliation concerns. It has an area for compensation and benefits, unemployment, workers' comp, and specific documentation. So it's a really good tool to use and ask these questions before taking any action on an employee. All right, now moving on to our last topic, which is supervisor audits. So the first thing you want to look at when you're auditing your supervisors, you want to see if they're keeping any of their own files, or what they're often called shadow files. If so, you want to make sure, obviously, you review these files because there may be some things in here that should be in a personnel file. So there could be, when you're looking at these files, hopefully you can collect and find most of them. Look at whether, are there any performance notes or evaluations, corrective action documents, medical information, which should not be in a personnel file, should be in a separate file, or any documents that resemble a misconduct situation. All of those most likely should be in an employee's formal personnel file. So you want to determine whether any of these should be transferred to an employee's formal personnel file. And lastly, when a supervisor leaves, if they do have a file, I guess it'd be a good thing to ask them. If you don't know, ask every supervisor or manager before they leave whether they had their own separate file, and if so, you need to obtain that. All right. One really important area when you're auditing your supervisors and their practices is training. And this is really important with respect to when we talk about, our last thing we talk about is personal liability, supervisor, manager, personal liability. So you want to make sure your supervisors are generally aware of the requirements of key laws such as the FMLA, ADA, Title VII of the Civil Rights Act, etc. If they're familiar with those laws, they don't have to be experts. If they're familiar with the basis of those laws, they may stop and think, oh, maybe I am not allowed to do that, or I am allowed to do that. So it's a great thing to train them on. And additionally, you want to make sure your supervisors and managers are familiar with all company policies, procedures, and when and how all these company policies and procedures should be applied. Another area in auditing your supervisors, we find that when we're reviewing or prepping a client for a trial of discrimination or responding to EEOC charge or anything like that, that a lot of times with supervisors, we're not sure whether they had the authority to act. They still did act, but they weren't sure whether they had the authority to act. So you want to review whether supervisors you have clearly delineated supervisor responsibilities for write-ups and investigations. You want to ensure, do your supervisors know when they have the authority to act? Be clear, give them examples. Do they know when they should seek help from their managers before taking action, or when should they get legal counsel involved? Those are all good areas to train them on. And you also want to see, whether the supervisors, are they too friendly with direct reports? That could lead to trouble down the road as well. All right, and finally, one area to train your supervisors on, well, to mention at least while you're training them, is personal liability. Do your managers and supervisors know that they can be held personally liable for illegal employment-related decisions? I know in Ohio specifically, supervisors can be held personally liable for harassment, discrimination, and retaliation claims. I know other states, New Jersey, New York, Massachusetts, Pennsylvania, Connecticut, Oregon, that's not a comprehensive list, but those are other states where supervisors and managers can be held personally liable for employment-related decisions. And I know at the federal level, there are some cases where supervisors and managers, HR directors, have been held for FMLA and FLSA-related actions. So when you're training supervisors, you can kind of put the fear of God in them and say, look, you can be held personally liable for employment-related decisions. So it's very important that they pay attention while they're being trained, ask any questions to clarify any training, everything like that. And as I just said, it's imperative that supervisors, they understand their legal responsibilities and they receive training on how to implement various policies and procedures which are designed to avoid such liability. Saying that a supervisor was trained in a certain law could be a good defense if a supervisor was facing a lawsuit. So that is all I have right now. We went a couple minutes over, so I apologize. But if anyone has any questions, I can stay around for a little bit to answer questions. And if you have any down the road, I could give Marvin my contact information so you can reach out to. And I will give this back to Marvin.
Okay, Olivia. And actually, I have your contact information. It'll be up on the screen in a minute along with mine.
Perfect. Perfect.
But first, let me make sure. Oops. Let me get to the right slide because I'm sure some of you are here for the SHRM and Whoops, we got wrong.
Do I need to change presenter here?
Yes, that's why it's not doing it. Okay. Hold on for the SHRM and the